House Judiciary Committee this Wednesday afternoon, April 2nd. And we're going to take some testimony on S-109, our miscellaneous judiciary bill. And we're going to start with Liz Smith, who I believe is going to talk to us about Section 19 of this bill. Am I correct? Do you have that in front of you? Thank you for being here, Liz. If you could identify yourself for the record and tell us about the instruments concerning real property validated, which we're all very excited to hear about.
Sure. Excuse me. Thank you. I appreciate the opportunity to be here and to discuss this. Again, my name is Liz Smith. I am counsel and state manager for CADC in Vermont. So what we have here is, and I listened in a little bit earlier when Eric Fitzpatrick was explaining this to you all. So I will say that his explanation was, very well placed and a good primer for me attending today. So ultimately, as Eric had stated, title searches are conducted, anytime that there is a transaction affecting real property. So putting it into, your day-to-day context, even if you were to refinance your property, ultimately a title search would be conducted and title insurance would be issued for that lender. There's two different types of policies that are issued in Vermont, ensuring either an owner, purchaser of property, or a lender of property. Lenders always require title insurance. So in most scenarios, most real estate transactions, a policy is going to be issued of either owner, lender, or both. So at the time when that title search is conducted, as Eric mentioned, there might be instruments of record that have what we would think of as somewhat administrative type of errors or scrivener errors. And that can span from things that seem, somewhat consequential to things that are less consequential. But what this particular statute does, and the addition is, it circumvents the issue based on the amount of time that particular instrument that carries that issue with it has been of record. So in Vermont, we have a 15-year statute of limitations that's actually within Title 12 relative to a claim to be made against real property. That's very simply put, but there's two statutes, 12 VSA 501 and 12 VSA 502. So the 15-year statute of limitations is not arbitrary, that number. That is based on the statute of limitations in Title 12. So looking at this, you have multiple sections, as Eric had mentioned, that are relative to many different scenarios that one could find in the land records that could amount to an issue. And the proposed addition here that myself and the real property section of the Vermont Bar Association are proposing, and as supported by the VMBA, is relative to a missing power of attorney. So effectively, if the instrument has been recorded for 15 years or more, and the authorizing document to affect that instrument, in this case specifically a power of attorney, is not of record, what this statute does is it automatically authorizes it or creates a presumption or validates that deed that has the missing power of attorney associated with it. So a power of attorney is required to be recorded for the conveyancing instrument to be effective if it is executed by the authorized power in a POA, a power of attorney. But again, after 15 years, this would, make that a non-issue.
Seems fairly straightforward. Would there be any opposition to this? Where would any opposition come from? I think it seems pretty straightforward.
I don't think that there would be any, to be honest. These are curative provisions that are not singular to Vermont. Maine has a similar validating statute. In fact, this language is predominantly derived from Maine statute. Connecticut has a very robust validating act as well, and this provision is located in there also. So I wouldn't anticipate opposition to this, unless the committee had specific concerns. I don't see any opposition that would arise.
Okay, great. Any questions for Liz? I don't see any. Like I say, this seems quite straightforward. Thank you very much for being available and for testifying. We'll probably still have somebody in from the Vermont Bar Property section just to cover all our bases, but I think that this section looks pretty good. So.
Okay. All right. Great. Thanks so much. I appreciate the opportunity. Take care.
Thank you. Thank you.
Okay. Bye.
All right. We'll go to Judge Zone. Are you also up in Maine right now, Judge? Or?
I am. We have a conference starting this afternoon on case flow management.
Yeah, we'd like to think of it as getting rid of the backlog. So thank you for being there and learning all the things we need to do.
Well, we have a team. Tim Leaders-Dumont will be with us up here, as well as you've seen Ian Sullivan in your committee, Josh O'Hara from the Defender General. He's a PD up in Chittenden, as well as one of our clerks is coming up too. So we're hoping that it works out well.
Is it in Portland?
It is in South Portland, yes.
Why didn't they invite the chair of the House Judiciary Committee? I love Portland.
They did. Actually, they asked, we were putting a team together and I stepped up and said, I thought you were busy.
Thanks a lot. Good job. Thanks a lot. Yeah, okay. All right, fair enough. All right, so we're looking at H 109. Hopefully you have it in front of you. And if we could just kind of walk through, I know that there's some parts are definitely were suggested by the court, but if there are other sections in here that you wish to comment on, we'll welcome those comments. So we'll just kind of walk through and just pipe in on whatever sections you want to weigh in on.
Okay, so Tom Zone, Chief Superior Judge. I think the first section I would touch on is section 2 on page 2. That talks about on lines 12, it begins. The change there recognizes that through the efforts of the legislature, we now have more than 34 superior judges, and we thank you for that. And we just wanted to make sure the statute reflected that. So it talks about the number of judges as are determined by the General Assembly as opposed to having a specific number. So we don't have to come in and change it again in the future if we get additional judicial officers.
How many judges are there now?
There are 40 superior judges, 5 magistrates.
Oh, okay. All right. I thought it wasn't updated. Okay. All right, great. Okay. That makes sense.
Section 3 on page 3 adds in on line 7 and 8, it adds in procurement of tobacco products just to make it clear that those cases go to the Judicial Bureau. Section 4 also is a Judicial Bureau matter. Last year, there was a change to make sure that masking was not permitted. Masking is when you have, basically what you do is you hide a motor vehicle conviction by someone with a commercial driver's license. It's not permitted under federal law. And it would be, for instance, if you have a CDL driver who was picked up for DWI and he goes to court and they say, well, we're going to give you a ticket for a parking ticket instead. You can't do that because it hides the offense. And so this talks about unless otherwise provided by law, which incorporates that provision for masking. So they cannot be masking in the courts.
Any questions on that? All right, good. Thank you.
Looks like section 5 was just on page 4. That was just some clarifying language. On page, next is section 6, lines 14 through 17, also on page 4. What this does is this would expand those who can have access to electronic case records from their office or elsewhere to the criminal, family, and probate case records, non-confidential records, which currently is not permitted. Under subsection A, there is internet access for criminal records for criminal justice purposes by criminal justice agencies, but others cannot. So subsection B expands that to allow it to any licensed attorney.
Okay, question, Ian.
Hi, Judge. Just one quick question. So it says Judiciary's public portal website. So I feel like when I log in, I don't log in through the public portal. I log in through the attorney portal. But
I believe that's or otherwise.
Oh, there we go. So, but it's for lawyers, so should it just be? Well, I don't know. I guess yeah. So otherwise means so they'll have what I wanted to avoid is just, it would be really frustrating if I had to log out of the attorney portal and then log into the public portal to be able to search other cases, and I couldn't just search it through the attorney portal.
I will check that, but my understanding is that you do not. My understanding is that when you are in the attorney portal, you are afforded access for cases that you're involved in. My understanding is that what would happen is you would have access to cases you aren't involved in as long as they're non-confidential. But I can confirm that, but that is my understanding of the mechanics of how that would work.
Right. So why is this needed then again? I'm trying to make sure.
So there,
yeah. Doug, go ahead.
It's funny. I was going to say Representative Goodnow can go right ahead with that answer because the attorneys are saying Representative Goodnow would have to leave his office, go over to the courthouse and go to the public portal to look at cases that he's not involved with, or he would have to contact the court to get copies of case records. And so what this does is it really streamlines that process. In some ways, it takes a burden off the courts. But the most important aspect is we've been contacted by a number of attorneys who have said they feel it's prejudicial to them because some aren't, they are put at a disadvantage to try to get information at times.
And if they're not in good standing, it automatically they won't be able to access. Is that the idea?
That's the idea. I don't know the mechanics of how that would work in terms of if we have some kind of checks and balances, but what I can do is try to see if there's a procedure to make sure that if someone's license expires, that so does their access.
Okay. All right. Thank you. Any other questions on that one? I think we're good. Oh yeah, Ken has a question.
Just the other thing I'll add to it, if you don't have to go to the courthouse or anything, if you can do it right from your office, it's going to save whoever you're representing time and money. And I mean, you bill by the hour, or you probably bill by the second, but.
I think I bill by the month.
I wasn't really talking to you, I was talking to him.
Oh, to him. Okay. All right. Yeah.
And the other thing that's kind of under this is that there are attorneys who have special access because they work with like the Defender General's office or something like that, who have this broader access from their portal right now. But those attorneys who don't have that special access can't. So there are some lawyers who are able to sort of look at more cases that are outside of the ones that they're personally involved with through their portal. And that's some of the inequity that I think
This will balance it out.
This will balance it out.
Okay. Good. Thanks.
All righty. Moving on.
Section 7, also we're on page 5. Line 7 talks about attorney's fees. This on line 10 crosses out the words upon hearing. And the reason for that is under Vermont Rule of Civil Procedure 80.1 subsection F, there is a provision that says the court can award these fees, but if there is an objection, the court can then order a hearing, would have to have a hearing. And what this does is it puts it in line with that. It doesn't say the court can't have a hearing, but what it simply does is it says the court is not required to have a hearing. And quite often there's no need for a hearing. You have default situations, and it seems pretty clear from the paperwork. So this saves the attorneys and the court time and the ability to schedule other things.
So it's consistent with, did you say it was a civil rules 80.1?
Correct.
Right, thank you.
Civil Rule 80.1 provides the ability of the court to address this very issue, and the court can order a hearing in appropriate circumstances.
Great. All right. Thank you.
On section 8, line 12, and section 9 down where it starts on line 18. Section 8 eliminates switchblades from the prohibition of criminal law at this time. Section 9 then says what you just eliminated is to be expunged. And we have checked. I believe there was a dozen, maybe 11 cases. I will tell you that we've already received the files. We were not able to tell from our records whether the violations of 4013 were zip guns or switchblade knives. When we received the files, our court administrator, Terry Corsones, last week, I believe it was, looked at each of the dozen cases and confirmed that what we now have are all switchblade cases. And I can tell you that there is no problem whatsoever with making sure that they are expunged after July 1st and before July 1st of 2026, because I have committed to, I said, if it's necessary, I'll take care of it the first week to make sure we get it done. So we can do that.
So will it impact it if we change to a ceiling regime under S12?
We can, just a different form I'll pop up. We'll make it work.
Well, you'll either seal or expunge depending on what we do in S12.
Either of them we can make work. It'll work perfectly.
All right, thanks. Yeah, Tim.
Just curious, Judge, and you may not know offhand, but how old are those switchblade cartridges?
Well, we had to go to public records for all the files, I think. Most of them, I think, were over, well, you know what? There may have been a 2016 or 2017, but most of them were back over 10 years old.
All right.
Section 12 on page 7. There's a change from on lines 13 through 16. This is for civil sexual assault and stalking cases. If someone's at a hearing, the law currently requires that the court has to transmit an order for additional service. You may recall that last year in your committee, it was requested that statute be changed for purposes of relief from abuse orders. And what this does is this makes the civil sexual assault and stalking orders consistent with what you did last year for RFAs, so that they don't have to be reserved and the court simply merits them.
All right, great.
Section 14 on page 8, lines 11 and 12. This is for guardianships. If a guardianship petition is filed and withdrawn, it remains open currently. What this does is it recognizes that there may be times that it's appropriate for a petition to be withdrawn, and if that's done, the petition is sealed. It's no longer a public record if it's withdrawn.
Okay. Any questions on that one? Nope, good.
We're going to jump ahead because we have to page 16. Section 20. This is perhaps the most important one you will address. On line 17, it changes administrative judge to chief superior judge. I just want to make sure that I do get paid for working.
It looks good.
Fair.
Section on page 17, on lines 10, well, actually section 22, lines 10 and 11. This is the Coordinated Justice Reform Advisory Council that was supposed to be repealed in 2028. We filed a report. A copy had been submitted to the committee, your committee, when we did that. Basically, the committee, the council had dealt with about $490,000 for determining where it should go. In our report, it was noted that given the fact that it was a low amount, given the administrative demands and the time constraints that were there, and when you look at the fact that it's 0.23% of the budget for Department of Corrections, and it's a very complex budget, the council thought that it made more sense to have this added to base funding and have the council repealed earlier and no longer be functioning. Since the recommendation was made by the council, I understand two things have happened. My understanding from Trevor Squirrel, Representative Squirrel, who's also on the council, is that $390,000 of the 490 was going to go to Lund. And they were pushing that to base funding. And the additional $100,000 was going to go to FACT, which I understand is the Forensic Community Program for Treatment up in Burlington, run between DOC and DMH. It's for individuals who are exiting the Department of Corrections who have severe mental illness. And so I think it was, as Isaac Dano commented when he let me know that information about the FACT monies, he said, it looks like you've just worked yourself out of business, essentially, because there's no monies left for the council to make recommendations on, because they're going to base funding, it looks like.
Although I thought there were some other obligations or requirements of the council as far as it wasn't just divvying up that money, or am I misremembering? I thought
the council, that recommendation was under subsection C of our report. We had other recommendations that we did make, and that's what you're looking at and talking about. We talked about the necessity of stable funding mechanisms, because some of the questions we were asked to address had to do with funding. We made the recommendations to DOC Commissioner. Plus, again, we're also supposed to address issues for funding for the department and how things should go forward. And we made those recommendations in our reports in terms of really looking at stable funding mechanisms, because of the fact that when you're funding community CJCs out of fines and fees, they go up and down and you don't have stability. So the council felt that it had achieved what it could achieve, essentially.
Okay. Any questions on that? No. Okay.
And finally, section 25 has to do with the firearm surrender working group. I see that it does reference the chief superior judge, and I'm certainly willing to participate as indicated therein.
Any other questions for Judge Zone on this? There will be some additional things we will be adding, and when we get to that point, we'll invite you back to comment on those other sections, but that's good for now. Anything else for Judge Zone? I don't see anything. Enjoy your time. What's that?
Do you need, I know that I was supposed to be scheduled for tomorrow morning, so I'm all set now, appearing today. Am I correct?
That is correct, yes.
Okay.
Yeah, thank you.
Thank you. Have a great day, everyone. Take care.
You too. Enjoy Portland.
Thank you.
All right, so we can go. Who wants to go first? Because Carolyn will certainly, even though we don't have you on a list, I mean, we are dealing with certainly the recommendation of the Fatality Review Commission.
It's okay with you. I can't come tomorrow morning, so.
Well, we'll hear from both of you today. We have time. Yeah. So what? Carolyn, why don't you start and then we'll go with Charlie? Is that okay?
I have some notes in there. Oh, yeah, sorry. I didn't know she was gonna call me.
Well,
I didn't get
well, you never, whenever you come into the committee, you never know. You never know.
My name is Carolyn Hansen. I'm with the Attorney General's office. Thank you for adding me to your list of folks to talk about this today. So this came from a recommendation of the Fatality Review Commission, just to create a study group that would look further at what's happening with firearms with people who are not supposed to have them. So the first and most important point that I wanted to make to you all today is this is not any sort of new restriction on firearms. There's nothing, we're not adding any restrictions on firearms. This is solely dealing with folks who are not supposed to have the firearms already because they're prohibited. Either they're prohibited by they have a criminal conviction that prohibits them from having a firearm, or they have a relief from abuse order in place that is gone through all the steps that requires them not to have a firearm. And basically right now, and I know you all have heard testimony about this already, so I don't want to belabor it. Happy to talk more though if you want to, is that we don't really have any mechanism for making sure that somebody who is supposed to have surrendered a firearm or who is not supposed to have a firearm, and then we get information they have one, we don't really have a process in place to address that. And it's really, I think, because we don't have sort of one entity who's responsible for that. I mean, law enforcement can go ask questions, but they can't go into somebody's house unless they have, a search warrant that involves a judge approving that and probable cause. And so FTAP, the Firearms Technical Assistance Grant, which I am part of, we have been talking about this and having conversations around this. And FTAP is restricted to looking at how do we use existing law? What's already on the books? What can we do right now? And we thought that a firearms working group made a lot of sense because there may be additional things that need to come before you all for approval in order for a system to work. And getting everybody in the room, decision makers in the room who can really put thought into this is a tough thing to do. But we felt like with a nudge from you all that this was something you wanted done, that would get the decision makers in the room. And what I didn't want to do is come to you with some sort of half-baked proposal that then a whole bunch of people come in and say, well, that's not going to work because of this, that, and the other. And then you guys get stuck in a whole bunch of like listening to everybody go back and forth, which I've watched happen here once. And it was like, oh my goodness, how are they ever going to sort that out? So what we'd like to do is to do some of that work for you all in advance and hopefully come in here. I don't know, we're going to have a proposal. I'm hoping we'll have a proposal. It may require some legislation. I think that's certainly possible. And we'll at least be able to lay out for you maybe a few options of how we can start to move forward. Whether we'll come up with something, perfect, I don't know. I just hope we come up with something better than what we have now, which is nothing.
So one thing, so I did have a chance, I mentioned this earlier this morning that before crossover, I had a chance to look into 221, H221, which is similar language. And one of the big issues is how big the working group was. And I'm trying to find the language that I actually was working on with Michelle that had what the working group was supposed to do, remaining what's in here, but having a smaller working group and then a requirement to consult with a number of these other entities, just to make it a little more streamlined. And I don't have the language, but that is something I'm going to be proposing. I don't know if you have any input on that at this point. You can always wait for language. I just want to give you that heads up that.
I mean, not in particular. We did think about all of these folks and some of them are aspirational. I mean, I did reach out to ATF to kind of get a sense of how willing they'd be to be part of our group. And I wasn't able to reach Alex. So I can't tell you that they're willing to devote resources to this. But I just think it's really important to try to get all of these different perspectives in the room. And, whatever, I've never put together any kind of study group before. So you have a lot more expertise in that than I would. But I just feel like as many people as we can get coming back again and again, because sometimes it's not as simple as like you just come in, present what you want to do, and then you don't hear the follow-up on that. So that would be the only thing is if we had a key person that we really wanted to have there, and they were just able to answer questions one day and then not come back. I mean, the power of saying we really want you in the room and you all saying that, I think helps to give people that nudge to be there. And I don't think anybody in here is somebody that wouldn't have a salary that already would cover their time being there. I don't think it's going to be a cost thing, but it's really just trying to get this group together, trying to marshal the right people in the room and have enough people that we feel like we can come up with a plan to present to you.
No, understood. And it's, I think in our experience, having too big of a group is often a problem, but making sure that laying out, well, first of all, that we take the responsibility of deciding who's in there so that it's not you, that it is not having somebody right at the table, but also making sure that they're listed as somebody that needs to be part of the process, but doesn't have to be at the table every time. It's more of a consultation. But we'll present that and get your input on it. I just don't have the language in front of me right now, but we'll be seeing that soon.
Thank you. Thank you for the opportunity to talk with you.
Yeah, no, thank you. So, Charlie could join us.
Good afternoon, Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. And thank you for the opportunity to testify on the miscellaneous judiciary bill. I would like to focus my testimony on two pieces. Section 25, which Carolyn did a great job speaking to, and a proposed addition to the bill for the committee's consideration. You have heard a lot about the Domestic Violence Fatality Review Commission and its recommendations. And I think that Carolyn did a really great job of articulating how this working group would be a meaningful step forward in looking at current law around legal firearm surrender orders, and find solutions about how to implement these laws better and identify any barriers to implementation. And we are very supportive of Section 25. The other piece that I wanted to put forward for the committee's consideration is a removal of the marriage license fee increase sunset. So this is a fee that is a revenue source for Vermont's Domestic and Sexual Violence Special Fund, which was established in 2008 and is administered by the Center for Crime Victim Services and supports community-based domestic and sexual violence services, like our 15-member organizations who are doing work across Vermont. So the revenue sources for the fund currently composed of two portions of two revenue sources: a surcharge on criminal and civil judgments and a portion of the surcharge on marriage licenses. So the revenues of the fund have been declining for many years. And in part, that is a result of some important criminal justice reform efforts. And as a result, the legislature has needed to allocate one-time funds to prevent significant cuts to services. In 2003, the legislature enacted a temporary 2-year increase in the surcharge on marriage licenses to help address the deficit in the Domestic and Sexual Violence Fund. And this surcharge is set to expire at the end of the fiscal year without legislative action. The language to eliminate this sunset was included in the Budget Adjustment Act, and it was also included in H9, which was sponsored by Chair Lalonde. So there's already a deficit in the Domestic and Sexual Violence Fund. And so if this increase in the marriage license fee were to sunset, it would worsen the deficit and further risk the critical services that direct providers of domestic and sexual violence services are offering to Vermonters. And so I wanted to put forth the consideration for that to be in the miscellaneous judiciary bill and offer to share any more information or answer any questions for the committee.
Yeah, I know I testified in front of Ways and Means at the very beginning of the session on, I think it's H6 that was built.
H6.
Yeah, so, okay, yeah, so I mean, we have the language and that's something that we can take a look at as well as a possible amendment. But I also understand that you may look to have that put into a bill down in the Senate. So keep us in touch as far as how that is going, because this is kind of a later bill in the session than probably what's down in the Senate.
Absolutely. Thank you.
Any questions on either?
How did we not do that already?
BAA.
That was in the BAA.
And it, yeah.
It didn't go through. Yeah. I mean, and something else that didn't. Okay. Thank you.
Thank you.
All right, I think that's.
So
Yep.
Firearms surrender order. Explain to me how that's even begun to be looked at?
I'm not sure I understand the question.
What are we trying to attain here? We're gonna have bad people that are just, or not bad people, can't use that. We're gonna have, criminals surrender their firearms. People that are doing bad things out there in the world, they're just gonna surrender their firearms. Is that what we're trying to attain here?
I will let Charlie answer that. I'm.
So under current state and federal law, certain criminal defendants are required to surrender their firearms for a certain period of time, as well as those who are subject to a final relief from abuse order.
Which is already in place.
Already in place. So this working group is only focused on better implementing current law and not expanding any restrictions on firearms.
So why do we need a study group if we're not looking to expand it?
Mhm.
And if we've already got current laws, and maybe, and I'll go one step further and I'll really put my mouth out there. if we're already doing the charges and holding people accountable, why do we need more laws?
So the current process for surrendering firearms is piecemeal. And so
What do you mean piecemeal?
there is not a uniform process for how firearms surrender orders are being enforced or that compliance with them is being monitored. And so even though it's current state and federal law that these firearms should be surrendered under certain conditions, sometimes they aren't. And so there are cases where it's falling through the cracks, and it puts survivors of violence in a potentially dangerous situation when people who are not supposed to be in possession of a firearm are. And so that's why it was included in the Domestic Violence Fatality Review Commission, because it stemmed from a case where a legal firearms order process was not appropriately executed as it's supposed to in the law, and it put a survivor at risk.
Yeah, go ahead, Karen.
We do have laws. We do have ways of charging people with a crime. So we can charge them with a crime because they have a gun if we have the evidence, but we still don't have the gun. And maybe the police will gather it as part of that investigation and it's collected as evidence. But what we're trying to do is not create a situation where people get charged with more and more and more crimes because they don't turn in their gun. We're trying to create a situation where they understand what they need to do next. Some people, they willfully don't do it because they're like, yeah, I know I'm not supposed to have a gun, but nobody's asked me for it. Nobody's told me who to turn it into. I still had it. Other people are like, I was really nervous in court and I didn't understand what I needed to do and I don't know what to do right now and I'm really scared. And so what we want to do is lay out a process and we want to make sure that that information gets communicated, not just at the time that somebody's sentenced or not just that time that they're in court and maybe really nervous, but it gets communicated as they move forward. So it gets communicated, let's say they're on probation, the probation officer asks about, you know, you're not supposed to have a firearm. The judge talked about that at your sentencing. Where's your firearm? We need to make sure that we know where it is and that it's secured until you're in a position to have it back. If you're a prohibited person, you're gonna have to sell it, right?
Don't we have laws out there already that you're supposed to surrender your firearms?
Yes, we do have those laws. What we don't have is what if? What happens next? How does anybody follow up on that or check on that? And so what we're trying to do is figure out within the realm of the law, what can we do? We're not going to be able to, in every single case, go looking in someone's house to see if they still have a gun. There'd be perhaps some situations where the person has done something that rises to the level of a crime, threatened somebody else with a gun, somebody's seen it in their house, knows it's there, cops are investigating it. That's the kind of situation you get a search warrant, not normally. But we can put checks in where we're asking and following up. So the judge has told the person not to have a firearm. What happens next? Is there any sort of follow-up? Even just a question from someone, even just, you know, asking about it again, even knowing, the judge maybe knowing, okay, I told that person to turn it into the police. It'd be nice if I knew, did the police get the gun? Because sometimes the police do get it. Like Charlie said, the person turns it in. There's no communication back to the court to let them know that that's happened. So we're just trying to figure out like, okay, somebody can't have a gun. How do we know that that happened? And is there ways that we can try to create a process so that we have more access to the information about what happened next? Do you see what I'm saying?
Yeah.
You don't like it though? You're like,
Yeah, I don't like it one bit.
tell me what you do.
It's just more grabbing a firearm, so you're not gonna keep the firearms out of bad people's hands. They're gonna get them somewhere else. And this is just another, now this is just turned into a massive firearm thing.
So just, and we're gonna have Chris Bradley in to testify on this as well. And I understand, at least initially, that there's support from those folks,
But there's,
for this.
oh, sorry.
Yeah, no, that'd be fine.
There's the thought of it is good. I don't have a problem with the thought. Following through with it without making more of a situation could be a huge problem. And I'm not really sure that it's needed if we already are holding the people that are committing these crimes or these situations. If they're being held accountable, I don't think we need more restrictions, for lack of a better word. We need accountability.
Okay, so yeah, we'll have some additional testimony. We'll probably have law enforcement and some of the other folks who are named who would be on here. And like I say, Chris Bradley is going to probably be coming in to testify on this as well.
Will this be Friday?
No, next week sometime. Why, you gone Friday? I would never do that to you. Tom, did you have a question?
I did just one quick one. I understand what you're trying to do with that, and I appreciate that. I would ask, do you not have a false sense of security if we do that?
I think you have a false sense of security right now. Somebody tells you you can't have a firearm. And then you find out that even if you call the police and say, well, I think he still has a firearm, they say, well, I don't know who's
Right,
supposed to do something.
so I do what appears to be right, and I turn them in. How do you know I turn them in? How do you know I turn them all in? You know.
You will never know. You will never be able to
Right,
create a
so-
system that's 100%, but that doesn't mean that we
But-
shouldn't.
To me, that makes it more dangerous.
The risk, the
If
real
you
risk
feel
is.
as though I'm complying, but I'm really not, it's in my mind, as a police officer, it's leaving a serious hole.
Mhm. Absolutely. I mean, I think we're absolutely in agreement on that. And I think right now, we see this working group as a step forward towards implementing these laws appropriately so that law enforcement is protected, survivors are protected, and that state and federal law is being executed as it's intended. It may never be perfect, but I do think that this working group could be a really important step forward in a better solution than what we have right now.
All right. So we will be taking more testimony on this one, probably next week, including any amended language as well. So other questions about this?
Thank you very much.
Yeah, thank you. Thank
Thank
you. I think that is all we have for today, unless people have other ideas of what we can do with our time.
No. I mean, yeah.